Kia ora and welcome everyone. Thank you so much for joining us today for this very important webinar on the upcoming changes to the Accredited Employer Work Visa and wage requirements for 2025. These changes will have a significant impact on businesses across various sectors. And today we are here to break them down in a simple and an actionable way. I am Aman Jaspal. I'm a senior licensed immigration advisor for New Zealand at 1881 Global. And with me is Samina Jaspal. She is also senior licensed immigration advisor at 1881 Global. Samina, these changes are some of the biggest policy shifts we have seen in a while. So let's dive straight in. Let's start with one of the biggest changes coming on the 10th of March 2025 is the median wage threshold is being removed for AEWV and specific purpose work visa. What does this mean for employers, Samina?
So this is really important for employers. The median wage that was across the board of 29.66 regardless of industry or profession, that from the 10th of March is no longer going to be a requirement. New Zealand employers, however, will have to pay at least the minimum wage, which from April 1st is going to go up to 23.50, but what's even more important is market rate. So employers will need to pay the market rate for the role. So that obviously changes depending on things like the role, the industry, and even location in New Zealand. So it's really important for employers to start understanding what the market rate for the roles that they hire for in their businesses.
Okay, that's great. Along with that, another important update is the work experience requirements for AEWV visa holders is dropping from 3 years to 2 years. Why is this so important for businesses, Samina?
So I think this is really important for New Zealand business because it's going to widen the talent pool. A lot of businesses find it hard to fill the positions that they need by finding somebody that's got that 3 years of work experience and maybe no qualification. So that 2 years, we're going to be able to fill vacancies faster, especially in industries like hospitality, construction, and even aged care, without facing unnecessary barriers that employers were facing so far.
Great. Along with that, there's another important change, Samina, with regards to the MSD and the engagement employers have with the MSD. Employer hiring low-skilled jobs, especially pertaining to ANZ SEO code level 4 and 5, must still engage with MSD. But what are the changes which have been introduced?
Yeah, that's right, Aman. So this was, again, like you said, for level 4 or 5 roles where we're not only advertising for 21 days, but we are engaging with Work and Income New Zealand. We would have to be obtaining the MSD skills match report. Employers still have to have that engagement, but instead of waiting for the report or providing that to Immigration New Zealand, they have to declare in good faith that, yes, of course, they have advertised the role with MSD and they have interviewed any suitable New Zealand candidates, and keep everything on record as you would do earlier, but it's just taking out some of that extra time that was going into to submit job checks because of all the extra requirements.
That's great. Carrying on with ANZ SEO 4 and 5 level roles, Samina, I think there's some changes regarding the duration of the visa that is also being granted to skill levels 4 and 5. Could you elaborate a little bit more on that as well?
Yeah, this is a really major change and a positive one, I think, when we're looking at earlier or up until now, level 4 or 5 roles could only have a 2-year work visa, and then they would come underneath a 12-month stand-down period. Now, Immigration New Zealand have recognised that a 2-year work visa is not really that long. Level 4 or 5 roles are now going to be able to have a 3-year work visa, and employees that you already have that maybe are on a 2-year work visa could be eligible for another 1 year if it's a level 4 or 5 role. So this provides some more stability in workforce planning. It allows employers to retain migrant workers for the longer period of time, without that hassle of again trying to find somebody to fill the role. So I think this is a really important and positive change.
That's wonderful. Great. There's also some important changes concerning the dependent children as well. I think that could be of interest to some businesses as well. the income threshold for supporting dependent children is increasing, in fact, to New Zealand dollars 55,844 per year. So what does this really mean for businesses?
So this is obviously an important consideration for New Zealand employers when they're looking at retaining their workforce and even new hires, because obviously migrant workers often want to bring their family in. Immigration New Zealand have, yes, you've said they've increased it, but this also ensures that that migrant worker can look after his children while they're in New Zealand. So it is really important. Employers, New Zealand businesses should be aware of this rate, because some of their migrant workers may not be able to bring in dependent children if they're on a lower rate. Again, this does not apply to visas that are already held by dependent children in New Zealand or any applications that are in process. It will come into effect from March 10th.
All right, great. That's good to know. I think it'll be helpful for a lot of migrants to know that, and for businesses also to ensure that the skills that they are getting, the employers are getting from overseas, may be interested in bringing their family. So that's these important changes. Great. Now, I think there are also certain roles being reclassified. Could you give us a little bit more details on what these roles are and what classification they have been granted by Immigration New Zealand?
Yep, sure. So we are expecting more changes as well regarding the ENSCO, but just for the upcoming March 10th changes, there are some roles. So those roles are pet groomers, nannies, scaffolders, and slaughterers. So they will now be considered as level 3 instead of level 4. So that means that if you're on a level 3, first of all, is the duration of visa is longer. It's, the 5-year work visa, but then also you may have potential residency pathways. So that's important for employers to consider, again, when we're looking at workforce planning and migrant retention as well.
That's great. So along with all these changes, Samina, what are the most important compliance areas employers should focus on in view of these current changes?
Yeah, definitely. I mean, it's like you said, really important around accreditation. All compliance must be met. So compliance at your accreditation level, job check level, it is really important to be aware of those. If you're not aware of those, it's really good. You can engage with us or immigration advisors that can assist you in understanding that your business is making sure that they meet those compliance. With the upcoming changes, really important takeaways are ensure that the job checks that you're submitting and the pay rates that you are offering from the 10th of March is going to be within market rate. You need to understand the market rate for your industry, for your roles, and even bear in mind the location where your business might be in New Zealand. Then also you must make sure you are keeping good record keeping, as you should be doing already, but within that accreditation, and also about your local recruitment efforts. Just because it may not be required to submit with a job check, it could be requested later on. These are still part of your accreditation compliance that you have declared you are going to keep doing. So not just your recruitment efforts, but also employment records. You must keep really good records. It's something that we can help you with. Get in touch if you want to understand compliance requirements, how these changes are going to affect your business, and how you can make sure that you're pre-planning and getting things ready now.
That's great, Samina. Now we can take some questions. We have some questions from some employers. Start with the Q&A session here.
Absolutely.
Sure. The first one, I have been struggling with the complexity of AEWV requirements. With these updates, do you think it will be easier or harder for businesses to hire migrant workers?
Yeah, that's a really good question. So overall, yes, it's going to be easier in many ways. Again, no median wage. There's 29.66, which was across, a lot of industries, unless there was a sector agreement where that was waived off. That is changing. So market rate means that it is now, you can now pay what you would be paying a New Zealander, not more for certain roles. The other thing is the lower work experience requirements. an accredited employer visa, applicant needs to show 2 years. If they don't have the relevant qualification for bachelor's or higher, that may need to be required instead of 3. So that's going to, again, make filling those roles with the right kind of people easier. They need to have 2 years, not 3 years. Longer visa durations, again, that is helpful in attracting migrants to New Zealand. Even if it's in a lower skilled role of level 4 or 5, they still will get a 3-year visa. So there's also reduced an administrative burden, again, having to fill roles from the employer side, every 2 years. The engagement, the MSD engagement has become simplified. It's still something that's a requirement, but it's more of an honest declaration than compiling all of the evidence together. So, of course, compliance is still there, but overall, it is going to be an easier process and easier to fill those roles that we really need to fill in New Zealand.
Fantastic. I think that would be that'd be great news for a lot of New Zealand businesses. Wonderful. We'll take up the next question, Samina. With these changes, will accreditation still be required, or can a business hire workers without going through that process?
Okay, so there's absolutely no change on this. Yes, you must be accredited if you want to hire and have offshore talent and migrants working in your business. Accreditation is a must. There's been no changes to that. What has changed is the wage and experience thresholds. But the actual process, you still need to be accredited. You still need to have a valid job check, and then to be able to move forward with hiring anybody offshore.
Okay, wonderful. We move to the next question. With no median wage requirement, should my business offer lower wages to migrant workers?
So absolutely not. It's not about offering lower wages. It's about offering the fair market rate, okay? So we're not offering, this is not about giving lower wages to migrants. Whatever you're paying a Kiwi in the same role of your business is what should be offered to migrant workers. It's also part of a job check that has to be approved by Immigration New Zealand. You can't use it to underpay workers as an employer anyway. Again, if you're offering a wage within the job check process that's not market rate, Immigration New Zealand are going to review that at the job check. So it's really important to understand those market rates.
Great. I think that's very important. I think these are very important points. Okay, the next one. Under the new declaration-based MSD requirement, what happens if my business fails to meet these obligations?
Yeah, okay. Again, a really good question. Non-compliance can lead to some really serious consequences. So, things like accreditation, suspension or cancellation. It's a really not a great situation to be in for a business. You can't hire new workers, but it also creates a lot of uncertainty in your business. There could be fines or legal penalties. There could be also further visa rejections. You've got to meet employment law and you must meet immigration law. So you must document the recruitment efforts that you're putting in and make sure that they can be called on at any time.
Another interesting question, Samina. Many businesses, especially in hospitality, aged care and construction, have used sector agreements to hire workers below the median wage. What happens to these agreements now?
That's right. So sector agreements were put in place so that there could be wage exemptions, and they were there for the hospitality industry as well as the care force. There were certain roles that were under that. So it's important to be aware that from the 10th of March, there won't be those sector agreements or wage exemptions. Market rate will apply for all. So you must offer, wages at market rates instead of at any previous sector agreement moving forward from the 10th of March. Again, if you relied on sector agreements to bring them at lower wages, that may have been something immigration looked at regarding market rates, but market rates is going to be the most important thing here.
All right, great. I think that's good to know. Moving on, are there any changes to the job advertising requirements for hiring migrant workers?
There are there are changes in what has to be given to Immigration New Zealand, but just to be clear, for school level roles 1 to 3, there is no advertising change requirements, okay? It's just the same as 14 days minimum advertising the same across all platforms, and making sure that when you are applying for a job check, if there were no New Zealanders or residents that were eligible for the job, that's declared, or if they were, that they should be looked at being hired first, okay? But for level 4 and 5, ENSCO roles, again, still advertised for 20 days. All of that still requires, you still must engage with Work and Income New Zealand, the Ministry of Social Development, before you can proceed. And again, that's 21 days. You have to declare that on the application. So the difference is, before you had to submit evidence of this. Now, as an employer, you have to say that, yes, you have done it, and declare that as part on the application.
Okay, wonderful. Great. Moving on, if a business employs a migrant worker who wants to bring their partner or children to New Zealand, what should the employer keep in mind?
Yeah. So again, if you want to be able to have an employee who's bringing their partner in, and that's something that they want to do, they have to be paid at least 26.85 an hour, okay, to be able to bring in a partner. Now, the changes have been made around for work visa holders moving forward that want to bring dependent children in. Now, you need to be on an annual salary of at least 55,844 per year. So it's really good for employers to understand that what these rates are, what that means for their employees or future employees when they're looking at bringing family into New Zealand, so you can plan.
Okay, great. Moving on, another question. For businesses that have already migrant workers working on AEWV, do they need to change the contracts or adjust wages for renewals?
So no. So if you've got employees already working for you, they're already on a visa, their visa requirements are the same until they may either apply for a further visa. Then you might need to look at those changes. So there are immediate changes for your employees. Obviously, you should always be keeping aware of how long is their visa valid for, and if you would like to keep them on, what is the planning for that? And I often, the employers that I work with, I say, this is something that you want to look at least a year before somebody's visa is expiring, right? Start having that planning. If they're applying for a renewal after the March of 10th, then yes, the new rules will apply. So that as an employer is again something you need to look at. Okay, we're still going to be offering a higher rate if it was at that. These discussions have to be done with the person that you're employing. If wages were based on the old median wage threshold, your business may need to adjust salaries if it was lower than what the market rate might be now. So there are two ways that this can go. And again, it is the right time to plan. These changes are coming in, within the next few weeks.
I think that's important, very important. I think a lot of time should go into planning. And if you need any advice, feel free to reach out to us. We'll move to just a couple more questions, Sabina. The next one, for businesses looking to offer long-term employment and residence pathways, do these changes help or hurt the process?
It's going to assist in a way because, as I said earlier, some roles are now going to be considered level 3 where they weren't maybe before. So things like forklift driver, excavator operator, there are certain roles and we can help you depending on your industry. Get in touch with us on there. Again, the 2-year work experience, so that is going to apply instead of 3 years if somebody may not hold the relevant bachelor's qualification or higher. Most often what we see is that immigration have their requirements, but an employer generally wants work experience as well as for that the degree. So I think this is important. Again, planning is important. But yeah, when you're looking at somebody for residence pathways, it's good to understand what those pathways could be from the start when they first are employed with you. Are they going to be meeting the residency rate as well? So all of that's really important.
All right, great. So just the final question, Samina, before we touch on the key, summarize the key points of today's discussion. Will these changes, do businesses need to update the employment contract? So with these changes, will the businesses require to change the contracts of the employers, existing ones?
So not of the existing employees on a visa, but again, looking forward, we have to always make sure that an employment agreement meets, again, employment law. There are employment law specialists that can assist you with that. And then, of course, immigration law, your job, your employment agreement must meet employment regulations. And that can't be changed. You can't, that's approved as a job check. That employment agreement that is approved in your job check is the one that you should be using with your employees. So it's just important to make sure you're meeting that immigration law requirements. Having an immigration advisor review your employment agreements to make sure it meets immigration law is very important.
All right. Thank you so much, Samina, for answering those questions. And thank you so much, everyone on the chat who's been asking them. We cannot take all of the questions, but feel free to reach out to Samina. She will assist you with any questions that you have specific to your industry or specific to your business. We'll be more than happy to assist you. So, Samina, before we wind up, could you summarize what are the key takeaways for with the policy changes, and what were your advice to businesses in New Zealand?
Yeah, my advice would be, depending on the industry that you're working in, is to understand, of course, market rate, getting your head around what does the market rate mean and how do we make sure that we are meeting that. Sort of stay informed. We can keep you informed with the different immigration changes. So just get in touch with us if there's anything you want to ask specific to your business, or if you're within the HR team, if there are specific questions that you've had, plan ahead. I think that's really important. Often we know that there are going to be changes, and then we wait until the changes are implemented, and then it's sort of, again, it takes too much time. So ensure recruitment and immigration strategies are, up to date. We can help you through that. And again, in the background, compliance, keep accurate records to ensure compliance. So you're meeting your accreditation compliance is really important.
All right. Thank you so much, Samina. And thank you so much for tuning in, and hope this was a helpful session. A lot of interesting policy changes that have come through. I think, as Samina said, a lot of it is likely to benefit New Zealand employers, although there are key takeaways that, stay informed, plan well, and make sure you're meeting the compliance requirements of INZ. Thank you so much. And again, if you have any further questions, feel free to write to us and connect with Samina on LinkedIn. We'll be more than happy to assist you. Thank you for taking the time. Thank you, Samina.